SJC-12895, Brian Racine v. Commissioner of Department of Correction, and SJC-12876, Raymond Harmon v. Commissioner of Department of Correction.
Good morning, Ms. Greenberg. You may proceed.
Thank you, Judge. I hope I don't have to introduce myself. I have been serving this court on behalf of the indigent accused for 25 years now, more. And I say that to preface a very brief apology for the very sorry state of my record appendix in this case. And I'll hope to repair that. And I will get back to that, the question of the record, at the very end of my argument. And I apologize.
Sure. Counselor, you may just want to state your name for the court proceeding record, the record of the proceeding.
Thank you, Justice.
We know you are, but.
I'm Ruth Greenberg. I was here last in Commonwealth versus Dagoberto Sanchez, and I want to speak briefly to Mr. Sanchez's case when I talk about mootness and third-party standing. The department has expressed objection to me continuing to represent these regulatory challenges, procedural challenges, policy challenges, when the people I originally represented are now dead. The problem with that is this is medical parole. By the time people get to me, they have to have less than 18 months to live. And because of various procedural roadblocks set up by the Department of Corrections, most of them are going to be dead by the time I get to the end of their cases. And I want to echo some earlier arguments we heard here today. Every day that a wrongfully detained prisoner is detained, it's at all our expense. And when we decide whether something is moot or not, we're looking sort of at a public policy problem. We need to address these problems. We need to address the regulatory roadblocks. We need to look at the intended beneficiaries of the statute, as Justice Lenk writes, and say the intended beneficiaries are not only the inmates, but also the public fisc, a very important beneficiary of the statute.
Ms. Greenberg, I hate to interrupt, but we have seen several of these, and the mootness part, we understand the standard and all of that. So let's move on to the actual arguments in this particular case, and we can ask your brother about why it's moot, okay?
Thank you, Judge. Let me start with a question raised by Mr. Harmon's case, and that is, and which is coming up in every single 249-4 I argue, and that is a question which seems to me the answer is obvious, and that is the question of the relief that the Superior Court or the county court can afford a prisoner who has been wrongfully denied medical parole. The department takes the position that courts have no power to order the commissioner to grant medical parole. We keep both sides cite the same cases. The court can order action an action taken by a member of the executive branch when there is no other way to do it. So what we're seeing in these medical parole cases is abuses of discretion by the commissioner and failure to grant medical parole for whatever her reasons.
Ms. Greenberg, forgive me, on a regular parole case that goes for judicial review, what options does a Superior Court judge have?
Well, in Commonwealth versus Clay, this court granted medical parole. In Frawley versus Commissioner, the court.
I asked you about regular parole.
Clay was a regular parole case.
Okay, you said medical parole, but you may have misspoken. Okay.
Yes, Clay was a regular parole case. The Department of Parole used the wrong standards, but in any case.
So I don't know if that's disputed. Yeah. So if the standard is, if there's an abuse of discretion and the Superior Court judge says no, the person should have medical parole, and we'll give Mr. Gordon a chance, is that disputed?
Yes, Judge. If I'm in agreement with you, and I need to speak no further to the topic, it's raised in every single medical parole case. And generally what happens is the Superior Court it delays things once again. It's a mechanism by which to interpose delay while the Superior Court is compelled to consider the question.
I mean, my memory of their dispute is whether or not this constitutes a constitutional violation, and we can, that's more of an issue. But anyway, I'll let you proceed.
Yes, let me say one more thing about this. What the court is empowered to do at the end of the case, which is to order the commissioner to grant medical parole, the court should be empowered to do in the interim. And the reason for that is the long time frame for these medical parole cases in the Superior Court, where we are getting scheduling orders of 2 years. So, and where the department is routinely delaying litigation in the Superior Court. The first thing that delays litigation is a regulation which appears to be extra statutory, which says that the inmate can't have the administrative record until 15 business days pass. That regulation delays things 3 weeks. It cuts into the statutory time period allowed for a person to appeal under 249(4).
Counsel, what do you think the reason for that regulation is?
None. Delay.
No reason?
Delay. That administrative record is completely prepared on the day the commissioner makes her decision. It's paper. It's on her desk when she signs her denial. And it would take about 3 minutes to scan it and send it to me. There's no reason that it should take 15 business days. And the reason that matters is because we then go on to the next stage of interpolated delay, which is I finally receive it. I file my complaint. I have the administrative record in my hand, and the department then insists on 3 months to file that record with the court. There should be no reason for delay at that point either. That's why, and I'm actually, because of your question, moving to the end of my argument. The department refers to a separation of powers problem with regard to Standing Order I-96, but the legislature didn't write Standing Order I-96. What we need for medical parole is a very shortened time frame for litigation. And that would solve, procedurally speaking, a lot of our problems. There's no reason when I get the administrative record that I can't file my complaint, the administrative record, and a motion for judgment on the pleadings immediately, because the record is time.
Can I ask another procedural question that I'm not sure I understand? If one of your clients receives a denial, and looking at it, they find that there's a mistake of fact that the commissioner made, what's their recourse at that point?
Oh, that's my favorite question, Justice. Thank you. Yeah, that's a softball. According to the regulations, which I protest as ultra vires, it's outside the statute. The department has passed and again promulgates a regulation which says that if there's a mistake of fact, there's no recourse, because the department says reconsideration is only possible if the person's health deteriorates. But of course, when there's a mistake of fact, that's not a deterioration. That's the commissioner either looked at the record of the wrong guy or made a mistake. We see this coming up. I'll reference the case of Charles Dyer, where the superintendent of the institution reported him to be cheerfully in population, but the fact was he was in the ADL under receiving full-time oxygen. I'll reference again the case of John McIntyre, where the superintendent testified he ambulated freely when in fact he was using a walker. So these are mistakes that I can't correct.
Ms. Greenberg, if we could stop the clock for a moment. I don't know if we have Justice Cipher.
Oh dear, I need her.
No,
We all do.
we all do. Hold on for.
He thinks I'm funny.
Hold on for a second. Let's try to get her back. Justice Cipher.
I'm in the meeting. Hello.
Yeah, we have you, Justice Cipher.
Gotcha. Thank you.
Okay.
Go ahead.
Ms. Greenberg, I know you're unflappable. Please continue.
I am undaunted.
Right.
And I'll back up 1 minute for Justice Seifert. Justice Budd asked me, what about when the commissioner makes mistakes of fact and how can I correct that? And the answer is I'm boxed in 2 ways. I can't. Under the regulatory structure currently available to me, to which I object, I'm not allowed to file a second petition to correct the mistake of fact because the petitioner's health is not deteriorated. Neither am I allowed to correct the mistake of fact in the Superior Court because according to the department, the record is closed. It's only the administrative record that's available to me to contest. A problem with that is because we don't get the superintendent's recommendation until after the commissioner makes their decision. The superintendent's recommendation is where error comes in. And I'm not suggesting at this time that any misrepresentation is deliberate, but I don't see it. So if there is a mistake of fact, I have no way to see it until the decision is made.
Can I return to the constitutional question for a second? Because the only case you cite is Clay. And Clay, there was actually an affirmative vote by, it's just the wrong number. They applied the wrong number, the supermajority, but there was actually an affirmative vote for parole. So I'm still not sure, are there any cases that say we can order parole besides Clay where there was actually a vote to require parole?
Judge, I'm going to back up a minute to answer that because I'm not actually asking you to order the parole board to do anything. In this respect, the parole cases are actually inopposite because the parole board is not granting parole. That's the difference. It's called medical parole because after the person is granted a release by the commissioner, then the parole board supervises the person who has been released. But the commissioner is not the parole board. The commissioner is like the chief of police. And her decision is it's the commissioner you're directing, not the court directs, not the parole board.
Yeah, but that chief of police case was like a parking ticket type of case, wasn't it? I mean, it wasn't.
It's a gun case, Judge. It's not a trivial thing.
But it's a licensing decision, which is different. We're talking about a constitutional separation of powers issue, aren't we? There's a difference here, aren't we?
Judge, constitutionally speaking, there's no difference between ordering the chief of police to do something and ordering the commissioner of corrections to do something. If a court were not empowered to order the commissioner to do something, then the court couldn't order the commissioner to reconsider. When we created 249.4 as a mechanism for judicial review, there was no intention that judicial review should be powerless. The court exists to correct wrong acts by the executive branch. That's Marbury versus Madison, this constitutional citation. Otherwise, there could be no correction when the executive branch acts in violation of statute. And
it's just not that simple, is it? I mean, I am familiar with Marbury versus Madison. We do spend a lot of time interpreting it, but with ordering something like parole, even if it's from the commissioner as opposed to the parole board, that just seems like that raises separation of powers. I'm not sure what the answer is, but it's not obvious and not so straightforward as you're representing it. We just do this all the time. We don't do it all the time. As far as I can tell, we've never done it except for in that case that you bring.
Well, Judge, I think the difficulty comes when we use the word parole in a context where the word parole is not the right word. If the Department of Corrections were to hold someone in prison past the completion of their statutorily mandated sentence, this court would order the Department of Corrections to release that person. If a person had a 2-year sentence and they were kept in custody 7 years, this court could order them released. You wouldn't send it back to the Department of Corrections Registry Division to recount it. You would order them released. And what we're dealing here is frankly a non-discretionary decision by the commissioner to grant medical parole. I understand that the decisions she makes, she has to employ discretion in judging them. But when a person qualifies for medical parole, notwithstanding any other law to the contrary, and that is in the medical parole statute, the commissioner is required to release that person, just the same as she's required to do that at the end of their sentence. If they qualify for medical parole, their sentence is complete, and the commissioner is obligated to release them, and a court has the duty and the honor and the authority to order the commissioner to do what she isn't doing. The Department of Corrections can't keep people in custody past the end of their sentence and this court have no ability to correct that.
Isn't it quintessentially an exercise of discretion?
I'm sorry, again, Judge?
It sounds like doublespeak. It's quintessentially an exercise of discretion, and we review for abuse of discretion, correct?
It's not doublespeak. It's an important due process question, and
I understand the importance of this to you, but you don't have to preface your remarks with that. What I'm saying is, if you read the statute, doesn't it say it's an exercise of discretion? You have to balance all these factors, and then judicial review is there an abuse of discretion?
correct. And if the factors are
Well,
found,
you just said it was non-discretionary. That's the problem with the doublespeak.
okay, so let me straighten myself out. Here's where we are. It's just like when a trial court decides, is there a probable cause for a search? The trial court uses his discretion in deciding whether there was probable cause. But when the trial court has used his discretion and made a finding of no probable cause, the trial court generally has no discretion to refuse to suppress. The remedy, the action the court takes, is non-discretionary. And that's an important distinction. It's a two-step process.
Clearly the commissioner can't say, in my discretion, this person is perfectly suited for medical parole, but I'm not going to do it.
Correct. But the court can say, in my discretion, I have found this person to have 7 outstanding warrants, and therefore I will not release him.
Sure, we can obviously say they abuse their discretion if they say, they have an open check kiting case, or they're dangerous because 20 years ago they did something. I get that part of it. But,
so when you're a superior court judge and you say, in my discretion, there was probable cause, and then the SJC hears your superior case.
I don't mean to cut you off, Ms. Greenberg. I don't mean to cut you off, but I will, because we've already gone around this, and I want to open you up to any other questions that others may have that are different from this topic.
I have, I'm sorry, other questions on this question?
Right, or any, let me just ask the justices if there are any further questions of Ms. Greenberg.
I have more
clarification.
I know you have more, but we have time limits, so let's ask for more questions.
Just a quick clarification, Ms. Greenberg. You said that if a sentence is completed and the inmate is held, obviously the court can order the release. But am I correct that the sentence isn't completed? If somebody is granted medical parole and released, they remain on parole until the completion of the maximum sentence.
Yes, that's correct, Judge. I want to speak very briefly to the problem of reconsideration on second petitions, because it's.
Well, you're over your time, so but I'll give you a very brief moment to address that issue.
Judge, I'll wait to hear from my adversary. Thank you. I don't need to pose.
All right, thank you. Mr. Gordon?
Yes, good morning, Your Honors. My name is Richard Gordon, and along with Bradley Salton, who is sitting here today, we represent the defendants, and may it please the court. Your Honors, there's 3 very distinct questions that Justice Lenk reserved and reported to the court, and that are therefore before the court. And the court should answer those questions as follows. With respect to the death of a prisoner during the pendency of his certiorari, a challenge to the commissioner's denial of his medical parole petition, the death will generally render the case, the certiorari case, moot. However, there may be limited circumstances in which there's a legal issue that is capable of repetition and yet evading review, and the public interest supports deciding it. And in those cases, we submit that the court has discretion to decide those issues.
So what about this time? Do you think it's moot, or do you think we should decide it in this case, in these cases?
Yeah, Justice, but we have not moved to dismiss this the appeal or anything as moot. We were successful in getting it dismissed in front of Judge Allman with respect to one case, and then with respect to the other case, Justice Link reserved and reported it. And certainly, once an issue has been reserved and reported, it's before the full bench. So at this point, no, Justice Budd, unequively.
All right, so let's move on to the second question then.
Yes. So with respect to the second question, so the regulations provide that if someone, a prisoner, has his petition for medical parole denied, there's essentially three options for that person. If they disagree with the commissioner's decision, by statute, their recourse is to file a certiorari petition under 249-4 in the Superior Court or in the Single Justice Session, which has concurrent jurisdiction over the cert petitions. That's by statute. That is their recourse. However,
so they don't have a chance to do a reconsideration, motion for reconsideration, if there's a mistake of fact, if the commissioner got something wrong through no fault of the prisoner?
So the second and the third options, Justice Budd, would be that they could request to reconsider or file a subsequent petition. We do not bar subsequent petitions under any. However, the regulation provides that you can only file a subsequent petition or request for reconsideration in the event that there's a significant and material decline in your health.
Right, but that's the problem, right, with the regulation, because if there's a mistake of fact, there is no decline, there is no material change, it's that there was a mistake made. So what is a prisoner to do? I'm asking, I understand what the regulations say, but isn't that what we're supposed to be deciding, if this is, if the regulation is in line with the statute and the purpose of the statute?
It absolutely, the question that's squarely presented is whether or not, as in Buckman, the regulatory scheme and that regulation is ultra-virus.
Okay, and what do you say?
Absolutely not, Your Honor. The statute does not have, does not discuss the situations in which there can be a subsequent petition. And so we submit that it is a reasonable gap-filling measure that the Secretary of the Executive Office of Public Safety and Security has created and has done so for a really good reason. With respect to reconsideration, Your Honors, reconsideration often favors the inmate because reconsideration can be done on a much more expedited basis than filing a new petition. And the commissioner already has most of the information available to her, or in fact, all of the information available to her when she renders her decision. And so if an inmate requests reconsideration, typically what the commissioner will do is just ask for updated clinical reviews and updates as to the inmate's status. So it's a streamlined process that eliminates a lot of redundancies. And so for this reason—
Are you finished, Justice Budd, with that question?
I don't know that the question was answered, but I'm not sure that it can be. So you can go ahead.
Okay, I guess I'll try to follow up on that. So, but what about the situation where, you know, as a lot of us were trial judges, where you simply mess up on the law and you want that brought to your attention, and you kind of, it's reconsideration is good for everybody. Under the regulations, that can't happen.
In the event of a screw up, Your Honor, that is why the statute expressly provides that the courts, the judiciary, has certiorari review. It is expressly provided in the statute.
But I guess the point Ms. Greenberg has is that takes so much time, where under the spirit of Buckman, as you saw, and getting these things done expeditiously, why not would we not hold that our normal rules of reconsideration that everybody in the court system is familiar with, if there's a mistake of law or a mistake of fact, that can be brought to the attention of the decision maker?
The time issue is very important. I'd like to touch on that, Justice Gaziano. So
Well, can you
with
answer that?
respect,
Can you answer that question before you say that? Because wouldn't that cut off a lot of time so that doesn't have to be certiorari review? That the Ms. Greenberg can go and say, hey, I know you ruled this way, but you made a mistake of law, or what you didn't consider is what this physician had to say.
Your Honor, the court is in the best position to correct these types of things, and the court can use whatever timeline it sees fit in terms of adjudicating these certiorari petitions. We've had a number of cases, Justice Gaziano, where the court has ordered expedited briefing.
Gordon, say that the commissioner is looking at this and he thinks it's lung cancer with a 2-year prognosis, and it's really pancreatic cancer with a 2-month prognosis. And then you say, well, no, go back to the Superior Court. That's like saying, no, you're dead, you're never going to get medical parole. Shouldn't the commissioner know, geez, I hit the wrong key when I was typing in the type of cancer? That makes no sense.
Well, Your Honor, certainly we haven't had a case in which the commissioner has made a mistake of such a magnitude. I know that is a hypothetical that is.
It's a hypothetical to make the point that if going back to the Superior Court is the choice, that a certain number of times, that's like saying you die in prison.
Your Honor, in the case that you pose, where the commissioner makes a decision and it comes to pass that there is a actual decline in the condition, I would submit that would be proper in the hypothetical that you just posed.
So you got to sit there and you got to wait a month until the deterioration manifests itself, instead of a month having all the treatment and decline be in a nursing home or in your daughter's home.
Well, the commissioner, when you request reconsideration, it goes straight to the commissioner, so she can make a decision on one of those within a matter of days, and not have to wait certainly the 66 days to render a decision on a request for reconsideration. So that's sort of the commissioner above all else, and the secretary above all else, want to do the right thing. And that is why, in this particular case, the statute doesn't provide for reconsideration.
But not the case with the legal error, right? If they wanted to do the right thing, wouldn't they be able to expeditiously correct their own legal error, as I would as a Superior Court judge, without having to go through the appellate process?
Well, I think as a Superior Court judge,
judicial review process.
I believe that the law is that if you're, as a Superior Court judge, that once a final decision and effectively a final judgment has entered, that the court no longer has the authority to reconsider after that.
No, trial judges get motions to reconsider all the time after they've ruled on a motion to suppress or whatever. And sometimes 90% of them probably just say the same thing, but there's a good 10% of them we say, geez, I didn't consider that, and I'm going to change my mind.
As someone who's filed a number of motions to reconsider, Justice Gaziano, I totally get that. But reconsideration is a route that you can take on the road to final judgment. But once final judgment has entered, the process is you have to take an appeal. And I don't think that a judge can reconsider something after final judgment has already entered. And
I would assume that Ms. Greenberg is going to file her appeal, but that she's also going to file a reconsideration to give them a chance to correct their own error.
She may very well. However, the statute does not does not mandate a different result here. I mean, the statute does not say what is to happen in these types of situations of subsequent petitions, nor does it say nor does it speak to reconsideration at all. And so therefore, the regulation has been promulgated, and it's provided this separate avenue of relief for inmates, but only in the case of a decline, because it's very similar to res judicata.
I think we've been around this when you started with Justice Butt, I think she had asked you about the issues, and you said there were 3. You've gotten to 2.
Yes. So there's 3 questions that have been reported to the full bench. So that's the second. With respect to the third and pretrial detainees, this is another separation of powers issue. Justice Link has reported the question of whether or not pretrial detainees. I'm sorry, was that a question?
No, I think we have some feedback. Go on.
Whether or not a pretrial detainee can be released on medical parole, and the answer to that question is no. As this court held in McNeil, General Laws, Chapter 127, it applies exclusively to sentenced prisoners, and there would be an obvious clash between the judiciary and the executive were the commissioner to have the authority to release on medical parole straight pretrial detainees after a justice of the Superior Court has, for example, ordered someone held without bail due to dangerousness or held on high bail, which they can't afford. And so for this reason, the agency takes the position that pretrial detainees are not eligible to petition for medical parole. That's what the regulation clarifies to the extent that there was any disagreement about that to begin with. And it accords with this court's holding in McNeil. Now, with respect to what happened to Mr. Racine, it's important to note that he was a sentenced offender who was sentenced to a term of years in state prison, and that at the time the commissioner denied his medical parole petition, and at the time she denied his motion to reconsider, he had pending charges which the commissioner took into account in determining his dangerousness and whether or not his release would be compatible with the welfare of society. However, he could have, the commissioner could have ordered his release on medical parole, but she didn't. And that was one of the reasons she took into account. And I think that she is entitled to do so going forward. But the agency, there's only 3 questions that are reported, and the agency takes the position that with respect to pretrial detainees, that they cannot be medically paroled, and the regulation is clear on that. Now, unless there are any questions on that, I would like to move over to Attorney Greenberg's argument that a Superior Court judge can order that an inmate be medically paroled. A Superior Court judge can order him to be medically paroled, and we submit in the brief that there's number one, it's not before the court. It's not one of the questions.
Wait, you know, the thing is, I think I read my reservation report, and I think I was broader than the 3 questions. I think it was that there was among those things that those 3 questions could be answered. I don't think I ever limited it to those 3 questions, so please go on.
Well, Justice Link, you would know better than I, since you were the judge that did reserve and report the question. However, there were 3 questions that were reserved and reported, and it is a big issue. And certainly, if the court were to consider it, I would hope that it would be expressly reserved and reported so that we could give it the adequate briefing that it does deserve. This was not a case in which a judge ordered Mr. Racine or Mr. Harmon released on medical parole and we took an appeal. This is not a case in which the Superior Court judge entered judgment on the pleadings in our favor because he agreed or she agreed that he didn't have the authority to do that. There are cases in which this will eventually, I'm sure, reach the court at some point, but it wasn't reserved and reported in this case. And so if the court does decide to go into the merits on this one, we submit that there's a huge Article 30 problem. The only case in which I am aware of the court ordering someone ever in the Commonwealth released on parole is Clay. As Justice Kafka pointed out, Clay is apples and oranges here. Clay was an ex post facto problem because at the time the juvenile homicide offender committed his offense, the statute said he could get out with, homicide offenders could get out with a simple majority vote. And then during the subsequent years, there was a new supermajority requirement that was passed into law. And so on the basis of that, the prisoner in that situation got more than a majority, but less than 2/3. And so the court did, in such a situation, order that person released on parole. But that is the only situation in which I am aware of a court of the Commonwealth ever doing that and that reaching the SJC level. And I would point the court to Amaral, and I would point the court to Cole for the proposition that there's a huge separation of powers issue here, and that the judiciary is not to act as a super parole board. So I see I'm well over my time, but if there's
Any further questions, Mr. Gordon? All right, thank you, Mr. Gordon.
Thank you, Your Honor.
Ms. Greenberg, I think you're going to stick around for the next one.
Well,
So we'll set that up, Mr. Keneally. And we have everybody. Mr. Keneally, if you could call the fourth case, please.
SJC-12961, Robert Malloy and another, v. Department of Correction.
Thank you. And Ms. Greenberg.
please the court. I'm looking for Justice Kafka here because he asked the right questions when I was here in Buckman versus Department of Corrections last year. The reason people aren't being released on their day 66 as a practical matter is because the department is not preparing the medical parole plans. If medical parole plans were prepared, the department could release on the 66th day. They're just not doing their job. And that brings us to the problem that we have here. In no case is the department doing it. And they're just not doing it. And last year I said I expressed my good faith that if this court were to require the department to do it, the department would, but the department doesn't. So that's why Mr. Malloy and Mr. Vinny were held past the 66 days. There was really nowhere yet planned for them to go. Now, what the department is basically arguing here is two things. First, they're saying that there is actually no statutory limit on the time that a person can be kept in custody following a grant of medical parole. That seems impossible. I mean, the whole medical parole statute is exquisitely time-bound. There's a calendar, day 1 to day 66. The total contingent parole plan is supposed to be done by day 21. I'm in complete agreement with the parole board who joins me on this. It's supposed to be done. Then they're supposed to check it in between day 22 to day whatever. And after that time, parole conditions are supposed to be set. And the only thing—
Can I ask you a question about just procedurally? Yeah. So are you saying that the commissioner granted medical parole without a medical parole plan being in place?
Yes.
Okay. Well, so isn't that the problem? I mean, why were they granted parole if there was no provisions for them for their care or for where they would stay? I don't get that.
Because the department has the obligation to make the plan.
No, I understand that. So how could the commissioner make a decision without having the plan?
It's just really foggy on all these cases. I mean, some of the cases that I have on 249-4 now, the Superior Court sends it back to the department to make plans. In Jerry Adrie's case, which I appended the record to the reply, the court sent it back to the department for plans 4 times. In Abercrombie versus Department of Corrections, Judge Pasquale just sent it back for the department to make a plan. In Prendergast versus DOC, they sent it back for the department to make a plan. That's because when the judges order release, they need to have a place to release to. But
would you just remind me, were these cases that happened pre-Buckman, so that the commissioner didn't, or the DOC didn't do it because they didn't realize they were supposed to do it?
I have to veer a little bit off the record. The Buckman was decided January 20-some. At that time, I had people with petitions pending and also people who had already been denied. And I reminded the department that Buckman existed, and the department took the position that they would not prepare medical parole plans for people whose petitions had already been acted on. I filed new petitions in order to have medical parole plans created. But the medical parole plans that are created by the department say things like, the guy might want to live with his sister. They are not fleshed out medical parole plans. And what the department is saying is basically what the department is doing in the grants is when it's granted is they're basically shifting to the parole department at the close the obligation to find, set, confirm, vet, and then they're holding on to the prisoner until parole does the job that the department was supposed to do between 0 and 21.
But according to Buckman, I'm sorry, according to Buckman, isn't it supposed to be a collaborative process where the DOC works with the people who are assigned to the facility, and along with people like yourself and prisoners' family members to put together a plan? I mean, they may not always be the ones with the most information about what's available to the prisoner.
Judge, supposed to be, to this day, not.
I'm sorry? Oh, okay. So it's supposed to be collaborative. That's what you're saying.
It's supposed to be collaborative, but the department declines to collaborate.
And in this case, again, with these two people here, in this case, were they granted the medical parole before or after Buckman?
After.
Okay.
The Department of Corrections lists a whole, lists a whole litany of reasons why they can't plan ahead of time. But they're basically arguing, I mean, my argument is two parts. First of all, they have to. But what they're saying is, first, they don't have to. And second of all, if they did have to, they just can't because it's too hard to do.
Well, isn't it true, or is it true that some places that have beds won't say yes until the person is granted medical parole? Is that true?
Judge, some might, but many do. And in fact, Farron Health Center, which is one of those referenced, does. And so that's why I think we didn't receive any facts on the department is trying to argue these difficulties by affidavit filed with its brief. If the court is going to decide that the department is excused from its job because the job is just too hard to do, then it needs to be set before a special master or a single justice for an evidentiary hearing on that topic. They can't just say too hard to do, here's my affidavit, because we contest all those facts and I made a motion to strike them. Certainly for Mr. Vinnie and for Mr. Malloy, where the department is arguing that there can't be an application for out-of-state parole made until after a defendant is granted medical parole, that's simply untrue. It's simply untrue in Mr. Vinnie's case that there were outstanding warrants. It's untrue that the Farron Health Center won't evaluate you before a release date is granted. In Mr. Adrie's case, where I appended the record, I'm sorry, I think I did, or I'm happy to. The department spent 5 months, and a social worker for CPCS did it in 72 hours, found a place. In Mr. Vasquez's case, which the court can take judicial notice, the department spent 4 months and made 4 phone calls during that time.
Can I pose a hypothetical to you? So remind me of the different timeframes, because this is a very short, compressed time period. What the commissioner has to do and what the parole board has to do. It's within 66 days. Go ahead, tell me quickly, and then I want to pose a question.
It's beautifully laid out in the parole department brief. The department makes a plan between 0 and day 21, and they must make a plan, and you've ordered them to do it. It's a statute, it's common law, and what a plan is laid out, and it includes a home plan, and they have to make really contingent plans, because I know nobody knows where they're going. So they could make 3 plans so that the guy can be ready on day 66. Then parole takes over.
So on day
Parole
6,
checks the plan and sets the conditions. So everything is ready to drop on day 66.
okay, but
That's-
the world doesn't, I mean, I'm familiar with the facts of these two because I was a single justice and
Right.
it was complicated. But let me just talk you through a second. So the critical factors are we need this person to have a safe place to go, and because these are deathly ill people, they need a place where they're going to get appropriate medical treatment and a place to stay, right?
Right.
So they need health care. Mass Health needs to do what it needs to do, right?
Right.
Mass Health needs to do something, and somebody needs to accept this person, right? What happens if everyone does the best they possibly can and those two things aren't in place? Do we order them home? What do we do? Because we're concerned. I understand he's been found no longer dangerous, no longer a safety issue, but he's a danger to himself if he's not properly cared for and protected. So if things don't work out, what do we do? Do we leave him with you?
Let me give you a variety of answers.
Well, but I'd like you to accept the hypothetical that sometimes we do the best we can and we don't succeed.
Okay.
So
I accept
what's going to happen on day
possibilities.
66 if that happens?
Several possibilities. Okay. One is in a case where the defendant did not want to be released because of a risk to himself, there exists the possibility of waiver. Second, in the brief filed by PLS on this question, the state hospital could take somebody. They're obligated to under the statute. It's a great brief by PLS.
So that's an option for us. So if, again, we do the best we can and we don't succeed, we can just order the person to the state hospital.
Yes, in the interim. That wouldn't release, I mean, what the department is trying to do here basically is not do its job. Because the department could set up contingency plans, just like a person would for their father. If he's this sick, he'll go to Aunt Rachel in Riverdale. If he's sicker than that, he'll go to the Hebrew home.
Ms. Greenberg, having dealt with this myself, it's not easy.
I know that. But I do want to say that last year, the department argued, I mean, this is what's called in British media, reverse ferret arguing. The department argued last year that this was so easy that the blind and deaf could do it without the ability to collect phone calls. It's not that hard. And when you do contingent planning, that's what I'm trying to express, it's less hard. So that where the department has passed regulations, which are entirely ultra vires, saying that the department can just wait as long as they want to while parole gets around to applying for out-of-state parole, the default position is custody. That's not doing their job. The default position is a plan in Massachusetts while waiting for out-of-state parole. The default plan is not he's safe, he's fine, he's qualified, but we're just going to keep him in prison an extra month and a half because we don't want to make a 4-week plan and a 3-month plan. They have to make 2 plans. That's what you do for your dad, and it's what they should be doing for their prisoners. 2 plans, maybe even 3 plans. Because what we're seeing is the department is applying to places 1 at a time. We don't do that for college. So what I'm saying, and we're not seeing collaboration, even now on cases where the department is ordered to create a real parole plan by the superior courts, the department is refusing to collaborate. So we're not seeing it. We're just in practice. The department has to be held to its duty by day 21. And then we have to fix mistakes of fact between day 21 and day 66. They have to work with us. And then we could. They can't just say that the default position for a person entitled to release is prison. It's not what the legislature said. The legislature said get to work and find them somebody. And I'm going to echo back again, it's tremendously expensive. It's $300,000 for a very sick prisoner to be maintained at the Department of Corrections. There's no private paying nursing home that costs that. They could have a contingent release to first available mass health rest home, and the public fisc.
Ms. Greenberg, just again, factually, it seems like Farron, everyone keeps coming back to Farron. How many, you've been doing this, how many of the nursing homes are taking people like this? Because it seems like we don't have a unlimited number of options. We have very few of these places that are willing to take sex offenders and first-degree murderers.
Judge, it's not correct. This is
okay, but what is your, based on the record, what is your record that we turn to for how many options there are like that? Just in generalities, I find this thing much easier than when we actually look at facts here. So tell me in the record, how many places take first-degree murderers and repeat sex offenders like we're dealing with here?
Judge, the House of Hope in New Bedford accepted Mr. Adry within 72 hours.
And
he's a second-degree murderer. They have expressed their willingness to accept Terry Abercrombie, who is a sex offender following a manslaughter conviction, and they have expressed their willingness to do that. The House of Hope has accepted parolees till way before I heard them. Parole is intimately familiar with the organization. That's only one. For Mr. Adry, we found 4, who has convicted of second-degree murder, we found 4 places within 3 days.
Could you clarify something for me, Ms. Greenberg?
Yeah.
You had mentioned the state hospital, so you're referring to the non-secure section of Shattuck, correct?
The Department of, Prisoners Legal Services has briefed DPH as a last resort, but certainly the Shattuck for hospitalized patients, a hospitalized patient can go to the free side of the Shattuck. Yeah.
And your position is, even in a situation of last resort, there's always that possibility, other than jail, of course.
I can't testify with certainty as to bed availability at the Shattuck.
Right now, I was going to ask you that about the capacity, but that might be outside.
These are fact-bound questions. I wouldn't expect this court at this time, without a fact basis, to say this job is too hard for the Department of Corrections to do.
Which is why you urge a master or some type of remand.
Right, but frankly, I don't think that's the problem, because with more money, they could do it. Go ahead.
Are you also asking us to rule that 66 days is 66 days, that they are out? Even though we have all this factual uncertainty out there, 66 days means 66 days, and they go no matter what. That's your position, right?
Absent a waiver, because they can always go to a DPH facility under the statute briefed by a PLS. There is nobody with nowhere to go. They can go to DPH. The statute provides for that when a person is sick. I'm sorry for not immediately coming to the number. Please look at the PLS brief. Or they can go, if they were taken out in a hospitalized person and wheeled to the Brigham would be obliged to accept them, and then they could die free at the Brigham. All they need is outpatient mass health, and they could just trundle them over. The Brigham would be obliged to take them, and and the Commonwealth would not be obligated to pay for 4 armed guards for a guy.
I'm confused by that. They're going to take them to the emergency room at Brigham and say, here, he's your problem. Is that really a solution? Is that really what you want to have happen, that we're going to drop them at the teaching hospitals just at their front door and put them in the emergency room? That can't be what
Judge,
you're doing.
I'm not suggesting that's optimum. I'm suggesting that the department do its job. as the statute requires them to do, and from which the court can't excuse them on the argument that they're finding it a little tricky. They have $800,000 in their budget for reentry planning. Every hospital in Massachusetts does reentry planning. Every nursing home does reentry planning, and somehow they manage it. The only people who can't manage reentry planning is the Department of Corrections, and that's because they don't want to.
Thank you, Ms. Greenberg. Any further questions? Thank you, Mr. Gaskell.
Thank you, Your Honors, and good morning. I'm here with Darcy Curry, who is my co-counsel on this, and I just wanted to take a moment to thank her for all her efforts in the brief and in helping me prepare for this oral argument. What we have here, just as we had before, are two distinct questions, irrespective of any individual inmate, and they're not about the extent of the commissioner's discretion, and they're not about who is eligible for medical parole. They're about what happens after that becomes a certainty, after the commissioner has agreed that this person is entitled to medical parole, is eligible for medical parole. And in answering the first question, I would say that the statute is silent as to who is required to find the plan or find the suitable home placement, and silent as to the timing of such efforts.
Wait a minute, can I ask you a question? I understand what the statute says, but if you keep Buckman, if you take that into consideration, is it not true that the DOC is supposed to work collaboratively with people who are assigned to the facility and with the prisoner and the prisoner's counsel and all of that to put together a plan?
Absolutely.
Including a place to live?
Including a place to live, and that is a plan, and it's a proposed plan, but as everyone who's ever made plans know, plans don't always come to fruition the way that they thought that they would. There's no denial here that the department is responsible for submitting a proposed home placement, but that home placement is proposed and not finalized. And I think that's the distinction here that needs to be made. There's a difference between securing a home plan, finalizing a home plan, and proposing a home plan. And 1709 of the Controlling EOPS regulation does provide a mechanism where a decision looks likely that the commissioner will grant medical parole. She refers the petition, including the superintendent's recommendation and the proposed home plan and proposed overall medical plan, to the parole board for further investigation and to set the terms and conditions of parole. 1711 also allows the commissioner to set separate conditions before the release on medical parole. And that is where the authority here is to say, we would grant this inmate medical parole. The commissioner has determined him eligible for medical parole, but he simply doesn't have a place to go at the moment. The commissioner will grant medical parole and allow for medical parole release to occur upon the securement of a home plan. And that is the best plan or the best operation of how to satisfy the legislative intent. The legislative intent would absolutely not be for the commissioner to say he's otherwise eligible, but he doesn't have anywhere to go, so he's denied medical parole.
But shouldn't the commissioner be monitoring the entire system for availability ahead of time? I'm confused by this idea that, I mean, obviously the legislature wants these people released so that they can die at home or die out of prison. It doesn't seem to make sense to me that we're waiting to the tail end of this when it's a system-wide problem. I mean, just dealing with Mrs. Greenberg's clients, there's a flow of them continuously going through the system. Shouldn't there be continuous monitoring of openings out there so when this actually happens, okay, this is a bed that will accept sex offenders. This is a bed that will accept murderers, so that we don't start over on day 59. I mean, we don't start the actual mass health process. Maybe that's more complicated, but we don't at least look for the bed after everything's decided.
No, absolutely, Your Honor. And it's not that we don't look for the bed, but as reported in our brief and from information received from a majority of facilities will not even begin to consider whether somebody was acceptable for that bed that you just discussed, before there has been a grant of medical parole. So it's a chicken and the egg situation.
Why is that? Why isn't it a criteria-based decision whether someone, I mean, they don't have to, I mean, is it a necessarily individualized decision, and that's why it's not a criteria-based decision? This is a person who needs intensive care and is a sex offender, or this is a person who is a murderer and needs 24-hour monitoring. I'm just confused by that.
I think it's both. It's both a criteria, as we have had facilities report certain classes of former inmates based on certain convictions will not be allowed to be admitted regardless. That's a blanket ban. But then it also is an absolutely individualized evaluation process. And most of the time, from what we've heard from facilities, is they won't even begin that evaluation until a grant of medical parole has occurred. So again, we could propose the Farron Center, and the Farron Center is where a number of inmates have gone, but it's a proposal, and the Farron Center will only start considering after a grant of medical parole. And I'd just like to speak to your earlier question. It's not that we're waiting until the last, day 59, day 60. The process the regulation does allow for when, or does require the commissioner to transmit the entirety of the petition, including any proposed home plans, to the parole board within 30 days of receipt from the superintendent's recommendation. And so that would allow the commissioner to have had an initial look at it. She determined that release looks likely, and she wants to begin the process as soon as possible. And that kind of jumps into the second question here, that the statutory and regulatory scheme in this case don't prescribe that the 66 days applies to release. The 66 days.
Can I interrupt you here? I've heard a lot about the regulatory scheme here. And I would like to know, because I'm a little confused about this. Was the regulatory scheme one that was in place at the time of Buckman? Have we ever ruled on this regulatory scheme? Is this regulatory scheme that you're relying upon something that we are to review in the context of this litigation? Or because I hear Ms. Greenberg referring to this as ultra vires regulation. And I'm just curious about the dates and whether or not we've passed on it and whether or not it's up for review because as ultra vires now.
So the regulatory scheme was adjusted following the Buckman decision, has been promulgated. The specific regulations related to this procedure in terms of release in the transfer to the parole board were not part of the sections that were invalid or were deemed invalid in the Buckman decision. So those are
have they been addressed in Buckman?
They weren't specifically addressed in Buckman, no.
Okay, so they've never been addressed by us, in other words. You're saying in sort of an encompassing way they must have been because we didn't say anything about them in Buckman, but that's sort of a negative implication. We've never really, in fact, addressed them.
Absolutely, and these regulations, there's nothing in the regulation that specifically says the commissioner may hold indefinitely, and the commissioner and the department as a whole understands the legislative intent here was very much influenced by the speed in which the inmate would be released. Obviously, the timeline was set in an effort to get them released as soon as possible. But more important than the speed here is the legislative intent, and Justice Cafferty, you brought it up, that the legislative intent for the medical care for these inmates and for the public safety and welfare, because it doesn't serve the public safety or welfare to release them to the street, especially when given the fact that they've been granted medical parole, they have significant medical concerns, and it certainly doesn't serve their interest in being released to the street. And,
wait,
and so
wait. I don't think she's saying that she's going to release them to the street. I don't think that's the alternative at all that she's suggesting is the possibility. But there's always a possibility of some other place. It may not be ideal, but it's not the streets.
I would argue that in some inmates' cases, there's not a possibility of another place.
What about the state hospital?
The state hospital, so the regulation relied on there is Chapter 151, Section 1, or sorry, Chapter 127, Section 151. And if you read this, in reading the statute, the language is clear that that obligation only kicks in at the expiration of a sentence. And the expiration of a sentence is not, as discussed in the previous matter, is not while somebody still is on medical parole. That the sentence has not expired. And for some who are those who have been convicted of life sentences, their sentence essentially never expires. As a further matter, this was not brought up raised by any party here. Obviously, PLS has raised it, but we can't speak for DPH. DPH is not a party to this case.
But
And
you're saying you are affirmatively saying that the streets are the alternative. You're affirmatively saying something, aren't you? You're not saying just that this subject is for voters outside of our. You're saying something that is in fact factually determinable, right?
I apologize if I misspoke. I didn't mean to say that the answer is actually the streets. I more meant to say that the alternative would potentially be homelessness for some inmates who haven't been able to find placement. But we do place within the DPH system. The DPH system has accepted one inmate, and it's on a case-by-case basis. And even that's the statute of Section 151. At most, I think that would require DPH to consider these inmates on a case-to-case basis, because again, they might not be the best facility to allow for them to allow for the treatment of that inmate. And I do just want to briefly address, beyond the two questions that were reported here, Justice Kafka requested a series of factual information. I do apologize, the clock seems to have left my screen. Oh, I see it now, thank you.
You're over time, so sum up.
Okay, so very quickly, a number of inmates have been released. And if you look at the statistical average of the inmates outside of a few outliers, this is a process that is working similar to that of parole. And I would just hope that the brief is, and the statistics that were provided by the reentry efforts were duly considered, and the fact that this is working. It's just some inmates take longer than others. Thank you, Your Honors.
Thank you, Mr. Gasco. Mr. Ravitz.
Thank you. Randall Ravitz for the Parole Board. The medical parole statute and regulation should be construed in a way that furthers the various goals of the legislature and that's consistent with reason and common sense. While the scheme presents substantial challenges, the Parole Board is committed to fulfilling its own obligations within the process. In answer to the reported questions, the scheme contemplates that officials will identify and investigate placement options within the 66 days leading up to the deadline for the commissioner's decision. It assigns certain tasks to the Parole Board prior to that deadline, but no role for the Parole Board in finding a placement after that deadline. Of course, there may be some cases where, despite best efforts, locating a suitable placement simply proves impossible. And in those cases, the DOC commissioner could rationally conclude that she cannot find the statutory standard met. But if the commissioner does determine that the standard is met, then officials should generally act with reasonable promptness to effect the prisoner's release. That is, after a short period of time for the statutory notification process. After all, expedition was clearly one of the legislature's goals, as this court recognized in Buckman. At the same time, expedition was not the legislature's only goal. There were clearly others. Among them were furthering the health and safety interests of the prisoner and the public, ensuring adequate financial coverage, ensuring that released prisoners will comply with the law and be adequately supervised, and compassion. And in circumstances where expedition would not further the legislature's goals, and may even be in derogation of certain goals, a reasonable postponement of release should not be entirely foreclosed. To be clear, we are not arguing that release could be postponed infinitely, as has been suggested, or simply at the whim of DOC. We are largely just encouraging the court not to adopt a rule providing that DOC must release someone immediately in every case, even if it would be in derogation of the legislature's goals. So I can entertain any questions from the court. And if there are none, then we will rest on our brief.
I think Justice Kafka has a question. He's unmuted now.
And I'm unmuting too, so go ahead.
I'm trying, and that sounds great in the abstract, what you just said. I'm just trying to understand though what it means. And what potential justifications would there be for going beyond the 66 days? That the placement hasn't been identified, that it's not a good placement? I'm just trying to get a sense of that. Mm-hmm.
Right. Let's say the 66-day deadline is approaching, right, and we just have no idea, or I should say DOC just has no idea where this person is going to go. DOC, the commissioner, would certainly be within its discretion, exercising its discretion appropriately to deny release if the commissioner can't reasonably find the statutory standard to be met. But let's say we're approaching the 66-day deadline and everything seems to be in place. We're just waiting on one little detail to be dealt with. We're waiting on, let's say, a form to be signed.
Let's
Yes.
say that detail is that the best place is the Farron Center, but they want to do an individualized determination and they're not sure they're going to have a bed. They may have a bed. DPH isn't a great solution. So can you just keep them there for months, or how does it work? You know, I'm just, again, I understand hard and fast rules present problems in something this complex, but I'm just trying to get a sense of how we put teeth and meaningful standards in place that both sides can live with.
Well, if DOC is essentially saying, we can't release this person until this qualification is met because it would be contrary to the public interest and contrary to the safety and the health of this prisoner, then the question becomes, so then how can the statutory standard be found met? And if the statutory standard is found met, then release should be effected, as we say, with reasonable promptness. Now, let's say, though, that something happens. The placement is lined up, the facility is, everything is in place, and then the facility closes its doors, goes out of business. Then the statute, read literally, would still say that the person needs to be released, but it would seem to be in derogation of the legislature's goals for the person to be released immediately, where it would endanger them, maybe endanger the public. So there, it would be consistent with the legislature's intent for there to be a reasonable postponement.
But the trouble is the reasonableness is in the eye of the beholder, isn't it?
Yes. I mean, it's, you know, quite honestly, adopting a reasonableness standard, I think, has benefits because all these situations are unique, they're unusual, the statute is still new, but yeah, it's the kind of thing where it's going to result in challenges, and it's going to, we're all going to have to figure out what reasonableness means, but that's true with any reasonableness standard in the law, and it's applied in other situations, and it's just something that...
Where did 66 come from?
I'm sorry?
Where did the number 66 come from? It seems like a particularly unusual number.
Right. It results from the addition of 21 and, I'm sorry, 21 and 45. So it's the 21 days between the petition and the superintendent or sheriff sending a recommendation and the other materials to the commissioner, and the 45 days after the commissioner receives a petition from the superintendent or sheriff and then has to issue a decision. So that's how we get the 66.
Mr. Rav, is it too simplistic to have a fail-safe in that if everything goes haywire and the plans don't go right, the person could get released to the non-secure side of Shattuck or have some other place to go other than the street, or being held and continue to be held in custody?
Well, that brings to mind the argument that's put forth by prisoner legal services that some people have referred to, and that the statute there, Chapter 127, Section 151, it's tempting, and it looks like it provides a solution, but there are some questions there about whether it would really apply, because it begins with the words, when a prisoner at the expiration of his sentence, as
No, I'm not talking about the statute. I know there's a statute and that could be disputed, but if we say 66 days means 66 days and the person has to be released, is it too simplistic, or is it desirable to have some type of fail-safe to say, rather than keep the person in prison or kick them out on the front steps of Cedar Junction, you can go to Shattuck or some other place?
That would be a solution, and that would seem to be consistent with what the legislature intended.
As opposed to having it be the continuation of custody as the default position.
Right.
How many beds are at Shattuck? How many beds are we talking about?
I'm sorry, I don't know the answer to that.
Okay, because, the idea that there's a fail-safe.
Right, and that's why I asked if it was too simplistic, and perhaps council could supplement the record with this information.
If
That's the danger with simplistic solutions sometimes, I guess, but maybe you'll tell us otherwise.
okay, if there are no other questions from the court,
Good. Thank you, Mr. Ravitz.
thank you.
And again, we'll take 5 minutes. We'll set up the next case, please.